Good morning, America, and welcome back to the Rhine Report. I'm Stuart Rhine, and the subject for today's podcast is the biggest traitors in American history, the Nazi Majority Six of Scotus and their cases. Today, I want to focus on what I consider to be the major factor in our steady march into a desperate form of totalitarian rule, and that is the Supreme Court, and specifically the 6 justices who are most responsible for this reprehensible transformation from a democracy into a society ruled and controlled by one man, made by them a king above the law, cruel, divisive, megalomaniacal, and functionally psychotic. It isn't my intention to oversimplify the situation, as there are certainly other factors which I have in past discussed, but the judiciary is the dominant cause of our present state of tyrannical rule. John Roberts, Neil Gorsuch, Clarence Thomas, Brett Kavanaugh, Amy Coney Barrett, and Samuel the Flag's Upside Down Alito. These jurists make Benedict Arnold look like an ineffective and innocent bystander. As I have recounted in another podcast, the Nuremberg trials, they can only be likened to the Nuremberg judges in their conspiracy, along with a number of unnamed co-conspirators, to pervert the rule of law, eviscerate, and legalize the destruction of our Constitution, spinning and plunging America headlong like a out-of-control alien comet into a presidential dictatorship and totalitarian rule featuring mind-boggling kleptocracy on levels never before imagined, and extreme cruelty, one from which we may never recover. This isn't some idle, accidental, or incidental Supreme Court happenstance. The conspiracy that exists derives from forces well hidden in the shadows, who have waited over the years patiently on what has become a perfect storm to twist our democracy into a fascist-styled Nazi, white supremacist, racist, anti-Semitic, intolerant dictatorship mirroring that of a collateral montage of Nazi Germany meets the dystopian George Orwell novel 1984. Before we undertake to illustrate, study, and analyze the main line of recent cases that have been used by Scotus to abuse the power of the law in their corrupt hands to actually legalize the destruction of our Constitution and the rule of law, here is a brief reminder of the tricks they've already played on us through the so-called despicable shadow docket, in which they take no responsibility or undertaking a justifiable interpretation of the law that allows them to arrive at any particular decision. As of December 9th, the court has issued 27 emergency orders in cases related to the second Trump administration, with 4 emergency applications pending and 3 withdrawn. The Trump administration has filed an incredible 32 of such emergency applications, and 2 applications were filed by the other litigant. Of the 27 cases decided, Trump has won in 22 of them. That certainly tells you something. Okay, so now we can discuss some of the key cases previously decided, as well as those with interim decisions made favoring Trump's regime and those yet to be heard and determined. The main cases. Obviously, we must commence our review with the one case that has flung open the doorway and floodgates to absolute tyranny, injustice, and deconstruction of our cherished Constitution. In the Supreme Court, Trump versus the United States, number 23939, argued on April 25, 2022, decided July 1st, 2024. Granted absolute official immunity to President-to-be Trump in direct and textual violation of the Constitution, and I implore you viewers to see the impeachment clause in which it is clearly stated that after an impeachment of a president, he can or she can be subjected to criminal prosecution. So this is the most egregious decision ever taken by a Supreme Court in the entirety of American history and its jurisprudence, surpassing Dred Scott and Korematsu cases, and it's had the additional benefit of ending Trump's criminal trials, 2 of them, for leading and formulating an insurrection and fake elector scheme against the United States on the one hand, to obstruct the constitutional, peaceful transfer of power so fundamental to our whole political process, as enshrined by the framers as fundamental to freedom and democracy, as well as his obstruction of justice case in the Mar-a-Lago court. Korematsu, I'd remind you, was really a case in 1944 in the middle of World War II, which validated the improper internment of Japanese American citizens. Let's jump to another Supreme Court case, Donald J. Trump petitioner versus Norma Anderson et al. On a writ of certiorari to the Supreme Court of Colorado. This case completely eviscerated and destroyed Section 3 of the 14th Amendment, making it utterly redundant. This is an amendment to the United States Constitution, but these 6 majority Nazis allowed Trump to be on the ballot in Colorado against the hearing not only in the trial court de novo, but heard by the Supreme Court of Colorado, in which it was judged he led an insurrection. Moving on. Again, Dobbs, state health officer of the Mississippi Department of Health et al. Versus Jackson Women's Health Organization et al., a certiorari to the United States Court of Appeals for the Fifth Circuit, which was argued in 2021, and it overturned Roe versus Wade, a preferential decision involving the privacy rights of reproduction and control over their own bodies of women. Next, there is Kristi Noem, Secretary, Department of Homeland Security et al. Versus Pedro Vasquez Perdomo et al. On an application for yet another stay, which was permitted by these Nazis, allowing for racial profiling of Latinos in search of illegal immigrants, obliterating the Fourth Amendment for search and seizure, the Fifth and 14th Amendments on due process, based on solely on the color of a suspect's skin, without any virtue of a probable cause or even a judicial warrant. In what is, I should say, a civil operation by ICE, and it's not criminal. Why were they carrying automatic weapons? Anyway, so let's move on once again to another disgraceful decision. And that is a decision that's forthcoming, which will overturn Humphrey's executive versus the United States that was settled in 1935 and is a presidential law which will probably be overturned or modified in such a way as to enable Trump to hire and fire officials of federal agencies created by Congress without cause, where in Humphrey's executor it was shown that you have to have cause, and the causes are specifically enumerated. And let's move on to another one. This one is very current. Louisiana appellant versus Philip Calais et al., Press Robinson et al. Appellants on appeals from the United States District Court for the Western District of Louisiana. This one absolutely destroys the Voting Rights Act of 1965, its remaining Section 2, in allowing for the racial gerrymandering of Louisiana to create white districts favorable to the MAGA Republicans, adding another 5 seats into the House of Representatives, despite the fact that the Voting Rights Act makes it clear that this is a racial gerrymander and cannot be allowed under constitutional law. And here we have Donald J. Trump, President of the United States, et al., applicants versus Illinois, et al., and this was docketed on October 17th, 2025, and it comes up from the United States Court of Appeals for the Seventh Circuit. And in this case, which will be decided eventually, it's all about the wrongful invocation by Trump's regime of 10 U.S.C. 12406 as an excuse to deploy American federal troops, National Guard troops, and Army and other military forces into U.S. cities to intimidate and frighten the hell out of citizens. And it's going to be decided in favor of Trump despite the Posse Comitatus Act, unless even these Nazi six can't avoid the sound and convincing argument of Professor Marty Letterman about Section 3, which places a demand upon the invocation which could not have been satisfied, and therefore the invocation of the law should be invalidated. Let's move along. How about birthright citizenship, where we have, again, Trump, President of the United States, petitioner, versus Barbara et al. On a petition for a writ, and this comes up from the First Circuit, and this is before judgment, as it hasn't yet been heard. The 14th Amendment, Section 1, states, and I quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state where they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law," which takes us back to the misuse of the Alien Enemies Act and other means to displace and hide away in foreign territories those suspected of being illegal aliens without due process. So it takes us back. So only a whack job Scotus would ever agree to hear such a ridiculous case. But they have determined to hear it. And that is completely frightening. And then as we move along in this wonderful tribute to the majority six Nazis, the Trump's impoundment case, which is clearly uninformed and unconstitutional, but is and has been in a sense heard. And this case is Department of State et al. Versus AIDS Vaccine Advocacy Coalition et al. On an application for yet another stay in favor of the Trump regime. This is involving Trump's administration plan to end the assistance that the middle-class working and vulnerable families and small businesses depend on. Now, where the Constitution of the United States of America in Article 1, Section 9, Clause 7, clearly states, and I quote, "No money shall be drawn from the Treasury, but in consequence of appropriations made by law," that is Congress, "and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time." The Constitution gives Congress the sole power of the purse, and nowhere does it give the president any unilateral power to either temporarily or permanently impound, steal, or withhold or prevent from being spent funds duly appropriated by Congress. Now, the Supreme Court recently allowed the Trump administration to temporarily withhold $4 billion in congressionally approved foreign aid in late September 2025, a significant, though interim, win for executive spending power, deferring a final constitutional ruling, of course, but allowing the withholding to proceed under the Impoundment Control Act. Right, so in allowing him to proceed under the Empowerment Control Act indicating a judicial deference again to the president's management of foreign policy funds over congressional obligations. This move, involving a pocket rescission, effectively paused all these lower court orders and signaled a potential expansion of executive power in federal disbursements, though it's not a final decision on the core constitutional clash over the power of the purse. Preposterous, but a presidential stay was granted. Well, in summation, I would say this, that I've tried to give all of you viewers and listeners an opportunity to actually focus on the judicial aspects of this totalitarian takeover, how it's not just been enabled, it's been engineered and considered over a huge number of years, and all it took was getting these 6 Nazi majority in place in order to let loose the horrors of authoritarian rule on the American people. I hope that some of you will hit the like button, will subscribe, and give me an opportunity to somehow defeat this magical inanimate monster known as the algorithm, to give myself a chance and an opportunity for you to get material that other people do not offer and seldom attack. I thank you for watching and wish you Godspeed. This is Stuart Ryan. Goodbye.